Let's head over now to Nairobi, Kenya, and the International Criminal Court has ruled that Kenya's presidential contenders, Uhuru Kenyatta, the Deputy Prime Minister and also the Finance Minister, the son of the country's founding president, together with the former Higher Education Minister, William Ruto, that they should face trial along with two other men for crimes against humanity arising from violence after the disputed election of 2007. We're heading over to Nairobi, Kenya now to discuss the ramifications of the decision, and we're joined by Ndung'u Wainaina, who's Executive Director for the International Center for Policy and Conflict. Ndung'u, thanks so much for your time.
Welcome.
4 officials out of 6 that have now officially been indicted by the ICC. The big question right now is what impact this is going to have on Kenya.
I think first is to correct your earlier statement. The correct position is that we have 2 top government officials, that's the Deputy Prime Minister and the Minister for Finance, Uhuru Kenyatta, and Francis Muthaura, the head of civil service and secretary to the cabinet. The rest is a member of parliament for Eldoret North, and the other one is a journalist. This has several consequences. One is that particularly the top 2, that's Mr. Uhuru and Mr. Muthaura, these being the top government officers, I think their continued stay in the office is no longer tenable. Yeah. They have to leave. The second thing is that when you look at the bigger picture, it puts the president in a very precarious position, where he has to look for replacement, yet at the same time retain some degree of cohesiveness within his government. In terms of political terrain, I think that it is going to be extremely difficult for Mr. Uhuru and Mr. Ruto to continue with their high-profile politics. They have to always bear in mind that certain key conditions were set on them by the court area, and I also believe that the court will not hesitate to put more conditions should they realize that their continued engagement when they are still subject to the ICC is risky to the stability of the country.
These cases being put forward by the ICC, what bearing does it have on Kenya in an election year? Because obviously we know that this is almost the end of a transitional power-sharing government, and the elections next year should actually be contested on the merit of each candidate and what he or she can offer Kenya. So power sharing is no longer an option. Each party has to come forward with its own set of credentials, and that makes it even more difficult because there's so many competing interests in Kenya.
First is that Kenya has a history of a very high degree of climate of impunity, which has been prevailing for the last almost 4 decades. And this ruling essentially has sent a very strong message that violence will no longer be a tool to be deployed for one to achieve political objectives. Secondly, it's a major deterrent effect to violence, which has been used tremendously. I think also when you look at it on the other side is that Kenya as a country has been put on the spot that it has to build significant, to consolidate its institutions and be able to build credible, respectable institutions that are able to deal with issues of criminality, issues of impunity, so that citizens can have confidence in it. And therefore those institutions will always being kept, being challenged. In terms of how you look at the post-coalition government, we must not forget that Kenya has a new constitutional order that has actually has shifted the power. That strong intensity that we used to have on the presidency, that has completely been whittled down by the fact that Kenya is moving from a centralized system of government to a devolved system of government, which means that interest here will have actually a significant varying. And the biggest contestation of power, actually, we are going to find it more around the counties than even more around the national space. However, that does not mean that the national space will no longer play a critical role. It will, and at this first general election that comes up either towards the end of the year or next year, whichever one comes first, still the presidency will determine a lot.
Right. Ndung'u, one of the judges at The Hague had a dissenting view, and I just want us to focus on this one a little bit. Just to paraphrase, he believes that the crimes that were committed, firstly were committed on Kenyan soil, within a dispensation of law that recognizes that these were serious crimes, which are punishable by Kenyan law. He also said that in terms of the definition of crimes against humanity, some of the cases that have come to bear do not adhere to the requirements of Article 7 of the Rome Statute. So basically, this is a judge who's saying the Kenyan courts must deal with this thing. And it almost reaffirms a viewpoint that has existed in Kenya that the ICC is actually not necessary in handling the whole issue around post-electoral violence. Will it strengthen the corner of those who've been arguing for some of these cases and trials to take place inside of Kenya?
3 points. One is that Kenya government had always had a chance and opportunity to be able to demonstrate political will to make justice at the local level. It has failed tremendously around this. Secondly is that putting Kenyan's institutions, historically they have failed. And it's just after the enactment of the new constitution where we have seen a lot of efforts being made towards building these institutions. It's going to take quite a significant time before those institutions has finally been well established, have been tested and proved that they can be able to operate independently and be able to deliver justice. This is not going to be within a short time. And that's why there was a whole questions about deliberation of a special mechanism, judicial mechanism that can be able to deal with that, so that that mechanism can be proved that it can be able to operate fairly without interference from any quarters. Right. And I think the third is that when you look at the entire questions about protection of potential witnesses, this has been one of the most crux of the matter. And Kenya does not seem to have a well-grounded and well-established witness protection mechanism. What we have is one which has been established, but it is still at its very primary level. And therefore means that for justice to appear to have been done, I think that one has to bear in mind that you have to have concrete and well-established institutions that has been approved and tested. Secondly, you need to have a mechanism and assurance that the witnesses who appear before the court are well protected. However, one challenge that actually, this is a point that has to be emphasized, that the International Criminal Court and the process that is going on there is only very limited and it's only scratching the ground. For a country that has witnessed the kind of impunity that we have been having, we are still having a glaring impunity gap that is required to be addressed. And that's why that it remains imperative that the local judicial process has to be deployed to be able to deal with the middle and the lower cadre of perpetrators. In fact, listening to victims, one of the single biggest worry they have is that if these perpetrators are not prosecuted, they still continue to pose the single biggest threat, not only to them as the victims and other communities, but even to the bigger stability of those particular communities. All
right, I think we'll leave it there. Thanks so much for being with us and just talking us through this ICC decision to build up a case against senior officials in the Kenyan government. Ndung'u Wainaina, who's Executive Director of the International Center for Policy and Conflict.